Ms. Story, I'm not seeing your client. Is she in your office?
She's on the it's Caitlin Metz BU 25. I think she's on her phone.
I know I'm not seeing her on my screen.
I've asked her to start her video and she declined it just now.
Okay. All right. I'll be honest, I've looked through some stuff and what I really need to know is why Ms. Story, your client is opposed to supervised visits if the therapist says that she will work with the child through the process.
Your Honor, my client's not opposed to supervised visits if the therapist is recommending those. We have an order on file right now that the children, their parenting time with dad and any visitation with dad will be based upon the therapist's recommendation, not mom or dad.
At the beginning of the hearing, the judge notices that Miss Story's client is not visible on the screen and asks if she is present. Miss Story explains that her client, Caitlin Metz, has joined using her phone but has declined to turn on her video. The judge acknowledges this and moves forward, explaining that after reviewing the case details, there is one main issue that needs clarification. The judge wants to understand why Miss Story's client appears to be opposed to supervised visitation if the therapist recommends it. The question is focused and direct, aiming to clarify whether there is resistance to following professional guidance regarding the child's well-being. The court is trying to determine if both sides are willing to cooperate with therapy-based recommendations. This becomes an important starting point for the discussion. The judge signals that understanding this issue is key to making further decisions. The tone remains calm but firm as the court seeks clarity.
And Ms. Lyons and I did that just because of the emotions that are involved in this case, in the criminal case. So if that's what the therapist ends up recommending, then my client is going to follow that, Your Honor.
But their position is that your client's stalling getting the children regularly to the therapist, making appointments, doing them weekly, so that progress can't be made for the therapist to make a recommendation.
Your Honor, I believe that is resolved. My client attempted to make payments via her card and they were declined. We reached out to Ms. Lyons and Mr. Metz has since put his credit card on the therapist's, I guess, account. And my client will be taking them weekly. The ones that she did miss or that the children did miss, they were sick, and our exhibits show that they weren't at school that day either. But she intends on informing dad of when they are sick going forward through the parenting app to let him know if those visits are not visits, but therapy appointments cannot be made, and keeping him updated on when they're rescheduled.
Okay. And Ms. Lyons, aside from your argument that mom is not being diligent about the therapy so that recommendations can follow, which is what your hope and goal is for your client, under these circumstances right now, if they are agreeing to the therapist's recommendation, and that is what you proposed as far as visitation, I'm not sure why.
Miss Story responds by explaining that her client is not opposed to supervised visitation at all, as long as it is recommended by the therapist. She points out that there is already a court order in place stating that all parenting time and visitation decisions must be guided by the therapist, not by either parent. This agreement was made due to the emotional complexity of the case and the involvement of a criminal matter. She emphasizes that her client fully intends to follow whatever the therapist recommends. However, the opposing side raises a concern that the mother has been delaying therapy sessions by not scheduling them regularly or consistently. This, they argue, prevents progress and delays the therapist's ability to make recommendations. In response, Ms. Story explains that there were payment issues that caused delays, as her client's card was declined. She adds that the father has now provided his credit card, resolving the issue. Moving forward, The children will attend therapy weekly, and any missed sessions were due to illness, which is documented.
We can't move forward and know that mom's going to be accountable to the court with regard to the therapy, and that he will get supervised visitation the minute the therapist is ready for that. In my view, what the therapist needs to do is process any trauma, talk about the relationship with dad, and then if there's a supervised visit, then see how the child reacts and work through that. And I mean, I don't expect this to be something that will take 2 years in therapy before it happens, I guess is what I'm trying to say.
I certainly understand that, Judge. Our position is the court's orders were issued ex parte, right? My client didn't get a vote in them, but that ex parte order says the children, and it was in August, says the children are already in therapy and they need to continue in therapy and no contact with dad until the therapist recommends it, right? And we were on board with that. I think it's important to note that this trauma that we're describing was one 90-second incident on July 17th of 2025, right? And my client has now gone 220 days with no contact with his only children. He can't get a photo. She's not giving him the address. She's apparently moved the children, won't give him the address. She won't tell him any updates about the kids. She's pulled them out of their sports. Their son has played competitive baseball for 5 years. She pulled them out with no notice to dad, all while saying, I'll keep you updated. There's no changes. As recently as 10 minutes before this hearing started, mom has now provided her address and has agreed every 2 months she'll provide a photo of the kids. But Judge, it's not, I understand that the court is now paying attention because this is the very first time we've ever come before the court, because we were trying to do this by agreement, candidly. But our issue is it took until January 28th for mom to even follow her own order, for her to even get the kids into a single therapy session. In 220 days, there has been one less than an hour therapy session solely at mom's hands. She has sole legal custody. She has sole physical custody. My client has no rights to see these children, right? And so our position is, at this point, his absence is causing more harm than whatever that 90-second incident was in July of last year.
Well,
And
all you
so-
need is the therapist to say that.
And we understand that, Judge, and we would love for the therapist to say that, but mom keeps canceling the appointments. They've had 3 and she's canceled 2 of them. And after the first cancellation, I spoke with counsel. I was assured there wouldn't be any more cancellations. And then there was an immediate cancellation. So
Miss Story continues by explaining that her client plans to keep the father informed about any missed therapy sessions through a parenting app. She assures the court that communication will improve and that updates will be provided regularly. The judge acknowledges this and then shifts attention to the opposing counsel, asking if there are any additional concerns beyond the issue of missed therapy sessions. The judge notes that if both parties agree to follow the therapist's recommendations, there should not be a major obstacle in moving forward. The court emphasizes accountability, stating that the mother must follow through with therapy commitments. The judge also outlines how therapy should progress, including addressing any trauma, discussing the child's relationship with the father, and eventually introducing supervised visits when appropriate. The judge makes it clear that this process should not take an unreasonable amount of time and expresses an expectation that progress should be steady and practical.
our request is to start some VEP supervised visits this weekend, see how the kids are doing. They're not acting out
I'm
in
not gonna do
school.
that. I'm
Okay.
not doing that. Because now it has been so long, and I will take all of that into consideration. And that could very well affect mom in the future in terms of my belief of her veracity and that kind of thing. But the kids were present in this hotel room or wherever this domestic violence
Yes, no question. Yes.
witnessed it. So whether it's a second or 10 minutes,
Mhm.
the trauma's there, and where they're supposed to
Understood.
have fun and they're in the middle of a vacation, they're in a different state. And so I don't want to underplay the seriousness of all of this. I do want to get him reconciled with his children. So I'm thinking that maybe we get a DC coordinator that will make sure that, they're corresponding with the therapist and that the therapist appointments are being made. And maybe we have a recommendation from that person as opposed to just solely a therapist.
I don't think my client's opposed to that. I think the parties are maybe going to struggle a little bit financially with that. Mom has now apparently moved to a third location, so now there are 3 housing bills, and they couldn't pay the first 2. They're drowning in debt. Their house has now been reported.
I signed that order for them to.
We did, yes, we did get it listed. I take that back. It's not listed. We did reach an agreement to list it. We've been asking for that since September. I guess all I would ask, Judge, then is can we get a review hearing in 30 days?
Sure.
If the orders are being followed, we can cancel it.
Sure,
But
absolutely.
okay.
We can get a review hearing every 30 days.
Okay.
Indefinitely.
Okay. Because if Mom does the weekly therapy she's now saying she'll do, that'll give us 4 more therapy sessions. We'll have a recommendation from the therapist about starting reintegration, and we can keep moving and get this case moving.
Yeah.
And we might have an update on the house too.
Usually in situations where there's prolonged lack of contact, where there's asserted violence issue, where there's asserted trauma issues with the kids, there has to be a gradual implementation, as you're well aware. And that's why I think if there's domestic conciliation, that plan can be worked out with, so that when this happens, this happens. If this happens, then this happens. And he can see further down the road.
Yeah.
Instead of just fighting for every inch all the time.
Yeah.
And Judge Satterfield, may I just say for the record,
Sure.
my client was willing, if the orders in the Colorado case said that he could have her address. I spoke with Ms. Lyons this morning, and I did not have that order from the Colorado court. I reached out to them, which was one of my exhibits in the email, and had not heard back from them. But Ms. Lyons provided that order to me in her exhibits, and I let her know that we would send that over to her, knowing that that was the order of the court. So that has been sent over to her. I don't want the court to think that my client is trying to withhold that information. We're just trying to follow the order of the criminal case as well as the family law case.
Okay. Well, and if you guys want to, I want you to proffer what you want to proffer for the record, and we can still go ahead and do that.
The opposing counsel responds by explaining that the current orders were issued without their client's input, as they were ex parte. These orders required the children to attend therapy and prohibited contact with the father until the therapist approved it. While they initially agreed with this approach, they now raise concerns about delays and lack of progress. The attorney highlights that the alleged traumatic event lasted only about 90 seconds, but has resulted in over 220 days without any contact between the father and his children. During this time, the father has not received updates, photos, or even the children's address. The mother allegedly moved without informing him and withdrew the children from activities like competitive baseball without notice. The attorney argues that despite promises of communication, very little information has been shared. Although the mother recently provided her address and agreed to send photos, this only happened shortly before the hearing. The attorney stresses that these delays are harming the father-child relationship.
I think that my client's
Have
main
you guys
concern.
dealt with collaborative resources before? Because that's who I'm thinking about. Or I really liked Paula Langworthy that I used, or somebody used the other day, and she testified. She was very good, but my understanding is that she's running for judge, and so she's limiting her caseload. I don't know who else. Stacy.
I think that probably Megan and I can come up with some names. I'm thinking more like Christy Campbell.
That's who I was thinking.
Also a GAL, because her price point's a little bit more favorable. I think the world of Paula. She's a mentor of mine, but she's pricey. She's real pricey. So I
Well,
think
I mean,
Megan
they
and I can
could
come up
start
with a
with
DC.
mediation works. Could start with mediation.
I think there's
But
probably,
I think we're gonna need recommendations.
I think we
it's
need a
serious
recommendation.
enough
So
case
yeah.
that I
And
need help with
yeah.
that.
And hopefully we can split Christy's fees and come up with
Okay.
something, Megan.
Yeah, we can do it.
All
We
right.
can figure something out.
Okay.
All right.
I agree
So
with
it's not
Ms.
gonna
Lyons.
totally hinge on the therapist, but there's gonna be coordination with the therapist. And then we'll have the DC recommendations. And hopefully an outline plan that's a progressive one in nature, as long as everything goes according to plan.
Mm-hmm. What is the court's next date so I can get our review on the calendar?
It's a little, it's a week later than 30 days. It's
March
March
19th.
26th,
Oh, okay.
which is a
Okay.
week, which makes it
Is that
48
at 9?
instead of 30.
That's right.
I have 9 o'clock, 10 o'clock.
I'm gonna
Those
just
are
do
my
9
two
again, Megan.
openings.
Yeah,
or-
I'm free that whole day, so whatever works for your
Okay.
schedule.
Okay. Let's just
Sorry,
do
I'm having a
9.
hard time hearing. My computer won't turn up anymore.
Oh, sorry. We'll just do 9 on the 26th.
Okay. Ms. Lyons, since
Yes,
this
ma'am.
is your motion to modify, can you journalize today? And also what you guys agreed to as far as photo and that kind of thing. What is your client's explanation, Megan, for withdrawing their son from baseball?
The argument continues with a focus on the lack of therapy sessions, stating that it took months for even a single session to occur. The attorney claims that only one short session has taken place in over 220 days, despite the mother having full legal and physical custody. They argue that the father's absence is now causing more harm than the original incident. The judge responds by saying that such conclusions should come from the therapist. However, the attorney insists that therapy is being delayed due to repeated cancellations by the mother. They request that supervised visitation begin immediately to assess how the children respond. The judge declines to make an immediate decision but acknowledges the concern. The court also recognizes that the children witnessed a domestic violence incident, which could have lasting emotional effects. The judge emphasizes the seriousness of the situation but also expresses a desire to help rebuild the father's relationship with the children in a careful and structured way.
Your Honor, he had told, well, my client right now has sole legal custody, so I'll start with that. But he has informed, and I mean Jackson, the minor child, that he wants to play basketball this year instead of baseball. And so she did give Dad an update on the app regarding that. So he's going to be playing basketball, trying basketball this year.
Has he been on a traveling team, or has he been associated or affiliated with whatever organizations exist where he lives, like the Farha group or Derby Rec group or whatever the case may be? Or has he been on a traveling team? He's only 10. It's not like he's 15.
Right.
He's only
It
10.
was
so-
it was a Genesis team. They did travel. And my client was called by the coach and notified. And the coach was like, "Why is your son not playing all of a sudden?" And he's like, "I don't know. I'm sorry. I don't have contact." He reached out to mom and mom said, it was one sentence. He wants to play basketball. So she didn't volunteer any of this information. That's kind of our issue here. There's been no communication from mom. It's just, they're fine.
Well, she's taken her
So-
sole custody status
Yeah.
pretty broadly.
Yeah.
And she did have the right under the temporary orders to make those decisions. So let's see how it fans out. If I need to get CASA involved, I only do those in a handful of cases. I prefer to save it for long distance situations where I'm concerned about the environments, or when kids are borderline sink kids, frankly. But I don't see that here. But If there start being issues about the children's best interest and, presumably both parents act in the best interest of their children. We know they don't always, but presumably they do. So if there becomes some best interest issues, we may have to have a CASA do some background stuff and figure out what's going on.
I think that's part of why Megan and I are kind of leaning towards
Yeah.
Krista Campbell, because she's
Yeah.
that GL, she's got that training.
Right,
Just trying to two birds,
Right.
one stone.
right. And she will talk to kids.
Yes.
She will.
So what kind of directive can you agree on the directive in terms of the order and what she's free to do?
Oh, yeah.
Oh, I'm sure,
Okay.
yeah.
Oh,
Just
yeah.
the standard, right, Megan? The
Yeah.
form?
Yeah.
The judge suggests appointing a domestic coordinator to ensure better communication and consistent scheduling of therapy sessions. This person would also help coordinate between the therapist and the parents, providing additional recommendations. Both parties seem open to this idea, although there are concerns about financial strain, as the family is already dealing with multiple housing expenses and debt. The discussion shifts toward setting a review hearing within 30 days to monitor progress. The judge agrees and explains that regular reviews will help ensure accountability. If therapy sessions occur weekly, the court expects meaningful progress and possibly a recommendation from the therapist within that time. The judge also explains that in cases involving trauma and long gaps in contact, visitation must be reintroduced gradually. A structured plan is necessary to avoid further harm and ensure the children's well-being. The goal is to create a clear roadmap rather than ongoing conflict between the parents.
Nothing crazy here.
All right. Do you want to do some proffer here so that you have a record?
What my proffer was as to our request for supervised visits starting this weekend, so I believe the court has already ruled on that. Our concern again is it's been 220 days, so whatever trauma the children may have suffered clear back in July has now been exacerbated by mom's actions in not getting them in therapy unilaterally, not allowing contact, not sending photos, not sending messages, nothing. So is it possible the children were traumatized? Certainly, we're not contesting that. But our position is mom has taken sole legal custody and used it to harm these children by not allowing contact with dad, by not allowing contact with a therapist, not even allowing the school therapist. She didn't even notify the school. The school therapist is free, right? And there
Well,
all the time.
When did he enter into his deferred judgment or diversion? I mean, obviously he shouldn't violate his bond or conditions of his pretrial release or conditions of anything. And she shouldn't either. So when was the day in which Colorado said you can go back to whatever it is you want to do?
Oh, that was December. Our
Okay.
position, though, is she reported to the court in order to get her ex parte orders that these children were already in therapy to deal with this horrific trauma they
I
supposedly suffered.
understand. And they're saying, yeah, she would have liked to, but the insurance, the costs, the issues.
Yeah, except that she also provided us proof that she didn't even call a single therapist to even try until October 28th.
Okay.
And
Okay.
the price point issue wasn't raised with us till last week, and same day it was remedied.
Okay.
I
And
think this is pretty clear,
that's well
deliberate
noted.
actions. Yeah.
That's well noted by the court. All right,
Okay.
let's run through your exhibits real quick. So the motion to modify is A. I
Yes.
looked at that. B is
It's the modified order. They call it a mirroring order that just says Judge Satterfield's orders control as to any contact with the
Okay.
kids. And they did separate orders for each child, so they're B and C. I guess I could have
Okay.
put them together. D is the messages where she says, there's no updates in less than 24
looked at
hours later.
that.
She says, I'm moving. She has now provided her address.
Okay.
I would note that it required a hearing to get that. She
noted.
E is our request for even a single photo of the children and her denying it. Again, as of 10 minutes for the hearing, she is now consenting. F is the school therapist saying, oh no, I haven't been told anything. I haven't met with the kids. Do you want me to? But he can't, of course, direct her to meet with the kids for free weekly because he doesn't have custody. G is, because
So
mom
what,
reported.
what's gonna be the involvement of the school counselor?
I don't know that there needs to be any.
Okay.
But my question to my client was, well, are the kids meeting with the school therapist? Because mom is now alleging it's too expensive. Maybe they've been meeting with the school therapist if they're so traumatized, or maybe they've been exhibiting behaviors at school if they're so traumatized. And so he
Is-
reached out and was told, no,
Is Prairie Creek a new school for them?
no,
No,
it's
Your
where
Honor.
they've gone their whole lives.
So he can get into the Andover Power School information and view it. Maybe he can't change
Yes.
anything or do anything, but he
Yes.
can view all of it. Okay,
Correct.
good. All right.
And that I believe is specifically allowed by the order too. I'm pretty sure council specifically put that in there.
Okay. And then
so-
G is the therapist that he tried to,
G is the therapist that their son is seeing, Jackson.
All right.
And we included that because we were told the therapist recommended less therapy for the child. So he reached out to the therapist to find out why they were trying to slow play the therapy. And the therapist said, oh, no, I'm available weekly. Mom asked for less therapy. Same with Exhibit H. Different therapists for a different child reported the exact same thing. I is my client's therapy records because he's been in therapy since August.
okay.
In compliance with the
Hang on a
orders.
minute. Megan, when did you start seriously conferring with your client in anticipation of this hearing?
Your Honor, we got this motion that Ms. Lyons just filed last week. And I was supposed to be in trial Friday, and then there was not much time to confer with my client on this matter.
Okay.
I will say, Your Honor, that as far as exhibit, sorry, I'm scrolling back through. As far as Exhibit F, the school counselor, my client was informed by Jackson after receiving these exhibit notebooks that he has been pulled out of class and lunch per dad's directive to the school counselor without mom knowing, which would violate the temporary orders there. I want that for the record. We weren't making that a big deal, but if we're going to make a big deal that they haven't even talked to the counselor, dad has directed them to talk to the school counselor. As far as Exhibit G and H, there may have been some miscommunication between Ms. Lyons and myself. What was meant to be conveyed to Ms. Lyons is that she could not afford the weekly therapy, and that she was requesting an agreement from dad to do bi-weekly, or if we could figure out some sort of payment to do the weekly. That has since been remedied. I think that is being painted to be more malicious than it actually is on my client's
Well, I
behalf.
will say G is most concerning to me because it's very clear the therapist said it was at the behest of mom, and because he's playing baseball and he had a conflicting or a busy schedule with baseball. I mean, that says what it says.
Yes, Your Honor.
That concerns me, and I'm sure you talked to your client about that. And sometimes it takes an attorney getting after their client for them to understand the level of cooperation and goodwill they need to try to offer. So,
Yeah. And may I proffer, Your Honor, because Ms. Lyons has gotten a chance to proffer, and I would like to be able to
yes,
do the
I
same.
will. Yes. Okay. So I is, hey, he's working his side of things, his program.
Yes, he's doing his
And-
individual therapy. He's doing his BIP, which is Exhibit J is in
Okay.
Jaguar.
Okay.
He's in compliance with that. He's only got 6 sessions left of that.
Okay, good.
K is his community service log. I will update it. He has now done 53 hours of community service.
Okay, that one I didn't quite understand. Where is that coming from? The Colorado courts?
Correct.
Okay.
We're just trying
I'm
to
not
show
really
he's doing
monitoring
everything.
that.
Do what?
I'm not really monitoring that.
And I don't think that you need to. There are both sides, both parents are on diversion right now. And so what we're trying to show is that my client is doing everything he can. He's complying with all the orders in both of the states. And it's our position mom isn't, right? We've got an issue with the house. Now it has now been listed, or well, we've reached an agreed order to list it for sale. Our Exhibit L is one of the financial concerns that we have, which is mom was living in that house. Mom signed an agreed order to pay the mortgage of that.
In the final portion, both sides present detailed arguments and evidence regarding their actions and compliance. The father's side highlights his efforts, including therapy, community service, and financial support, while accusing the mother of delaying therapy and limiting access to the children. The mother's side responds by emphasizing the trauma she experienced, including being assaulted in front of the children, and asks the court for understanding and patience. She explains that her actions are influenced by safety concerns and emotional recovery. The judge listens carefully and acknowledges that both parents have faced difficult circumstances. The court concludes that while the situation is not ideal, progress has been made. The judge expresses confidence in both attorneys and stresses the importance of cooperation moving forward. Regular review hearings will continue to monitor the case. The goal is to ensure the children's best interests are protected while gradually rebuilding family relationships in a safe and structured manner.